Appeals Division 1 is now in session.
Thank you. You may be seated. We're here today in our case number CR230542, State versus Donovan Richard Larriba Tucker. We welcome students who are here visiting. We appreciate your interest and your willingness to come and watch these proceedings. Each side will have 20 minutes. Appellant, if you want to reserve time for a rebuttal, you should try to keep track of your time to save some time to do that. These proceedings are being audio and video recorded, so we'd ask you to identify yourself and your client when you begin speaking. We've conferenced this matter already. We think we're familiar with the facts and the issues, and if you could keep that in mind as you conduct your argument. And with that, counsel, you may begin.
May it please the court, I'm Stephen Willihan here on behalf of Mr. Larriba Tucker. I want to thank you for hearing us orally on this argument. There are two issues presented for you to decide. The first issue is whether the evidence was sufficient to establish that Larriba Tucker knew that an official proceeding was about to be instituted when he told the others to get rid of the knife and the shirt. Now, the rule I'm asking you to apply is that where knowledge of future actions by a third party is an element of the offense, as it is here, evidence that the defendant knew of a circumstance that will cause those required actions by a third party is also an element of offense. The state carries the burden of presenting that evidence. The facts here show that the criminal act of telling the others, get rid of the shirt, get rid of the knife, occurred, prior to 11:16 p.m. on the night of the killing. And we know that because the video from Safeway where the accomplice threw the knife into the trash, it was time-stamped 11:16. Now, the 911 call came in at 11:14. When the knife went in the trash, the shirt had already been thrown out the window on the way to the Safeway. So by the time the knife is thrown in the trash, the criminal investigation had barely begun. And
is it no or should have known?
Well, it says no.
You have to adopt it.
It says
he
right.
knew or he should have known?
No, knowingly.
Well, knowingly, we usually go with should have known as well, correct? I'm not going to. I don't agree to that. I mean, I still think that even if it is should have known, he should have known that there was a 911 call.
Well,
he knew that an investigation was about to begin.
Agreed. I mean, he left the victim with his friends and told him to take this guy to the hospital. He knew there was going to be an investigation, but that's not the issue. That's not what the statute prohibits. The statute prohibits doing that knowing, or if you will, I mean, that an official proceeding is about to be investigated.
Official proceeding is different it's part of the tampering statute, but for the obstructing a criminal investigation, isn't that different? And that's just you're obstructing a criminal investigation by means of intimidation, of force or threat. Could you focus on the obstruction convictions? First, you would say you have to have absolute knowledge that an investigation has started?
Well, I'm not going to insist on that because it seems to me like, for example, the guy in the memorandum decision that was cited by the state, he I forget what is meth or marijuana, he's smoking meth, and then then the cop sees him, and the cop is arresting him, and they argue, well, he didn't know an official proceeding was about to be instituted. And maybe he had hope that, although the cop was right there and was going to,
Well, official proceeding is different in my mind than an investigation.
Yes, I agree.
Tampering's a different argument, but just
Yes.
an investigation seems like an investigation could start as soon as there's a 911 call.
Agreed.
And so don't we want people not to obstruct an investigation we don't want people to intimidate witnesses and say, don't get involved in an investigation. Isn't that the point of the obstruction charges?
Yes, but we're talking about two different statutes. And you need to apply the statute, not what we want, but what the legislature has prohibited, and in their wisdom, I would say, excluded the investigation phase from the obstructing, or rather, from the tampering with evidence statute. Now, the obstructing a criminal investigation, it's right in the title. Don't obstruct a criminal investigation. And the ways that you can do that are in there. The way here that he was convicted of was saying no snitching. So the issue is whether those words, no snitching, that's a criminal act. And the rule I'm asking you to apply for that issue is that when a criminal act that you're seeking to punish is speech, and the speech in question is susceptible to a non-threatening.
But I think the criminal act you're trying to deter is to intimidate potential witnesses.
Yes.
Isn't that so? What's your best argument that Larriba Tucker did not attempt to intimidate witnesses into not participating or cooperating with an investigation?
It is simply that the words no snitching on their face are not a threat. So the question of...
You've indicated in your briefing that the term snitching is a synonym for tattletale. But isn't it for the jury to decide if the word has a more menacing connotation?
It is. And, the thing is that they probably should have been instructed with the rule that I am about to announce, which is that when it's ambiguous, when it could be one way or the other, the state carries the burden of proving that it's the threatening meaning that was intended and not the non-threatening meaning. And the evidence here, the prosecutor himself arguing, explained why it's intimidation. He said, well, now, he says no snitching, and he's drawing them into it. He's making them feel that they're part of it. So the inference there from the according to the prosecutor's argument, is that that Larriba Tucker is saying, don't talk to the police or we'll all be in trouble.
Isn't there testimony, though, from the witnesses that sent chills down their spine, or that they were afraid?
Yes, and the fact that they were afraid is perhaps necessary, but not a sufficient evidence to sustain the conviction, because what the state has to prove is that Larriba Tucker knowingly attempted to threaten or intimidate.
So what was he saying by no snitching?
He was exhorting his friends, his brother and his brother's friends, not to talk to the police. Just telling somebody, don't talk to the police, that's not...
He was telling them after he just stabbed someone. Don't you think that carries a little more weight?
Well, it certainly would give, perhaps...
For me, all right?
Yes. No, I understand that, but it's still susceptible of different interpretations. We don't know that...
I agree. And don't we leave that up to the jury to determine that?
Yes, except when the evidence is equivocal and...
No, that's not true. A lot of times the evidence is equivocal, and then we say, jurors, it's for you to decide the facts of this case.
True. But here again, I think that what was missing was a correct understanding of the law, which is that when there is ambiguity, and this is speech is protected. The First Amendment protects speech, and so in order to
First Amendment protects threats.
Does not. But that's right.
That's my point.
No. But in order to overcome First Amendment problems with punishing speech, you have to establish that it truly was a threat. And again, when it's just the language, there has to be evidence showing that, removing the ambiguity. So, if he had said snitches end up with stitches.
Let's back up.
Okay.
What instruction was missing? I thought the instructions were pretty clear about the elements of what they had to find.
Yes, and I didn't argue that, an instruction should have been given, but, going forward, I think that the law should be the law needs to be developed, and when the speech is susceptible to non-threatening, so the instruction would be something like this.
Isn't the law that if it's subject to more than one interpretation, we submit the evidence to the jurors and let them decide?
Yes.
And they weigh that in conjunction with the testimony from the witnesses that
Yes.
say they were frightened by what he said? So
Yes, but they have to be instructed with the understanding that the state has the burden of proving, of removing the ambiguity of the situation, of the speech.
They have to believe the state has proven the point beyond a reasonable doubt, which
That-
they were in this case.
Yes, but that it's a true threat and not, don't talk to the police. As in the case, one of the cases cited, it was,
Counsel, even if that was all he said, is don't talk to the police.
yes,
Couldn't that be interpreted as a threat?
no. I mean, no.
Could a jury reasonably conclude that was a threat?
Okay, so
That's the test.
with more evidence, with other evidence,
Yeah, the evidence that he had just recently
So,
seen somebody.
so for example, I mean, I'll just give you an example of how they did not develop the evidence, that maybe it was there, maybe it wasn't. You chills right up and down your spine, yes. Why is that? Because I thought if I talked to the police, what he was going to get me and do to me just what he did to Alex. Or, why did chills run up and down your spine? Well, I thought that now I was in trouble too. I'm involved in this murder, this stabbing, and I'm afraid of what the police will do. And it's a matter of the evidence wasn't developed, and
wasn't the evidence also developed, though, that the witnesses initially were apprehensive, did not
Yes.
come forward, and they weren't completely truthful with
Yes.
investigating officers? Doesn't that support the proposition that they viewed the term "no snitching" as being threatening? Don't tattle on me.
no more than the concern that if we talk, we're going to get in trouble.
Well, that's your interpretation. But the jury was free to interpret it somehow differently.
Well,
And if they interpret it if they're following their instructions and said, this is what the law is, and the state carries the burden beyond a reasonable doubt, and they interpret the statements and what was presented, then isn't our job ended? Yep. Because you're talking about a sufficiency of the evidence claim at that point in time.
yes.
And we always defer to the facts in the light most favorable to support the judgment.
Well, yes, the facts are more favorable to, the facts. But the facts are just that he said no snitching. Now, if you're talking about inferences of what's in a person's mind when the person says something, you have something else coming in here, which is the requirement of the First Amendment that this has to be a true threat. And it has to be...
Did you ask for a First Amendment instruction?
No.
But
Yeah, no, the trial attorney didn't, it didn't occur to me
that
actually until
argument's been waived.
Well, you could say that, but what I would say to that is that, I'd like to reserve, we're here working on these issues, and, sometimes the big picture, I don't get the big picture. I see it this way. The state files a reply where, there's a court that has considered this, that, the First Amendment has, it's implicated in the decision. And, you can choose to say it's waived, but I mean, I think it's your responsibility to keep in mind the big picture. And,
I think you have a better argument if he had simply said, we should all just keep to ourselves. But when you use terminology, no snitching, that's a pretty loaded term. It's hard to...
Well, it is loaded for us in the criminal justice system. I mean, I mean, we know about this stuff, but I don't know that,
Others haven't.
there's no evidence that it is, and I'm, in my experience, I can't say yay or nay. If when I was in high school and, somebody's cheating on the test and, don't snitch, they're not going to, I don't know. And so that's why I'm saying we don't know. Judicial notice isn't good enough. There should have been evidence. I mean, in these other cases that were cited, there was other evidence. I mean, they asked him, well, what is no snitching? He asked, what does no snitching mean? How hard would that have been? But they didn't. And so, the evidence was insufficient. And with that, I'd like to reserve some time for rebuttal. Thank you.
Good morning, and may it please the court. Celeste Kinney from the Attorney General's Office on behalf of the state of Arizona. The defendant's convictions were supported by overwhelming evidence. For count 4, the obstruction statute does not define intimidation or threat of force. The case law cited in the briefing shows the wide range of evidence that other courts have found sufficient for that. On the one end, there's Zapato, where
Can I
there's...
ask you about the other count, the tampering count?
Yes, Your Honor.
Under what, the legislature has defined the term official proceeding. How does an investigation fit within the statutory definition?
The definition for it did include an investigation, and that was in the model penal code version of the statute, and that was removed. It's
Doesn't that suggest a conscious choice not to include investigation, tampering with an investigation, as opposed to tampering with evidence that will be used in an official proceeding?
Yes, Your Honor, but the evidence here shows that he knew that he was tampering with an official proceeding. He shaved his head.
No, you need to define what you believe an official proceeding is.
An official proceeding, I believe, is a criminal prosecution, and in state...
When charges have been filed?
Yes, Your Honor.
Were charges filed at the time he made the statements in this case?
No, Your Honor, but one thing I want to point out is the timing in this case. The 911 call came in at 11:12 p.m. The school resource officer, Officer Stephen Jones, testified that he got a call between 11:30 and midnight about finding...
So does making a 911 call start an official proceeding?
Under the criminal rules of procedure, to start a criminal proceeding, charges need to be filed. But in this case, they knew who the suspect was right away. The fact that they couldn't get into a courthouse...
So what you're saying is they're going to have an official proceeding?
Yes, Your Honor.
But they hadn't filed it?
Correct, Your Honor. It was 11 o'clock at night, and in between 15 and 45 minutes, they knew exactly who these suspects were. They sent multiple officers throughout the night to find these suspects. This wasn't a case where it was a cold case, and they didn't know who was the assailant. They knew right away.
Means we know an investigation started right away.
Yes. Although
The investigation has been taken out of the statute.
Yes, Your Honor. And in State v. Neal, although I didn't cite it for this proposition in my brief, that exact same argument was made by the defendant in that case, and Division 2 found that there was no merit in it.
And that's a memorandum decision?
Yes, Your Honor. It is.
So it's not binding on us, and it's not binding on us even if it was an opinion, and it's contrary to the plain language of the statute.
It is not binding, but it is persuasive. And
That depends on how you read it.
How is it persuasive if the language of the statute, they apparently consciously chose to exclude investigation in talking about tampering with evidence? It says once an official proceeding has commenced or is about to commence. But under your theory, anytime someone shoots someone and then they throw the gun into the river 1 minute later, they've tampered with evidence?
yes, in the Oregon case cited by my friend on the other side, the defendant swallowed drugs right in front of the officer after he said he was under arrest, and he was charged with tampering with physical evidence.
And did Oregon have an investigation part of their statute?
I don't remember the statute off the top of my head, but in that case, they wouldn't need an investigation because he committed the criminal act right in front of the officer.
But even assuming they don't have it in theirs, it still seems inconsistent with the language of the statute that says a an official proceeding. It's just an investigation is not an official proceeding. We haven't charged someone. They might be investigating more than one person. And it seems odd. Why do you need tampering in this situation? We have other, you can obstruct, someone can hinder, but tampering with evidence seems to be something where they've specifically chosen not to include tampering during an investigation. It's tampering when there's an official proceeding that's either commenced or is about to commence. So I'm having a hard time squaring whatever case law there may be with just the language of our statute.
The language of the statute includes a criminal prosecution because it's when evidence is received by a legislative or government body. If we were to give, my friend on the other side notes about the timing of it, and there's this investigation, I understand the court's concern, but if we were to merely ignore the realities of this would lead to an absurd result. They couldn't know.
It wasn't absurd. They took investigation out and required an official proceeding. And you just told me maybe 2 minutes ago that an official proceeding is when charges are filed.
In this particular case, the stabbing happened at 11 o'clock at night. There was no courthouse open. They couldn't file charges right away. They need an arrest before charges are filed. So in the Oregon case, for example, the defendant swallowed the drugs right in front of the officer. They couldn't go to run to the courthouse and file charges right away. There's a process that leads to it.
Well, what's the absurd result, though, where you have a murder conviction, so you just don't have an additional conviction for telling someone to dispose of a knife and some bloody clothes, but you've convicted someone of murder. Why is that an absurd result in this context?
Because the legislature could not have foreseen this and give defendants a free pass. That he took very specific action.
Why did they take out the word investigation? Because it seems like an investigation starts as soon as there's a 911 call, arguably.
Correct.
So you're saying anytime somebody throws away evidence, they've got a second conviction on top of the serious crime of murder. We also need to convict them of throwing away the knife, throwing away their T-shirt, throwing away their pants. They can have 5 more convictions for just throwing away the evidence as they're fleeing the scene of the crime?
Yes. In this case,
So you didn't answer the question. The question posed was, why would they take out investigation? Because you've just written it right back into the statute.
I don't know why investigation was taken out.
But you admit that investigation was taken out, so investigation is not sufficient under the statute.
Investigation was removed from the statute, but the facts here show that he knew an official proceeding, a criminal prosecution was about to be instigated, and I think the most telling fact of that is that him and his brother concocted an alibi defense. If you didn't know
that, there's a lot of things that go into whether or not they have enough evidence to file a charge. He didn't know that they were going to ever file charges. He knew they were going to investigate the charges, but he didn't know they were going to file the charges. There are many murders that are not filed upon.
Yes, Your Honor, and very rarely in cases do we know the defendant's actual intent. It must be inferred from the circumstances surrounding the event, and I believe here the defendant's actions show he knew that there would be an official proceeding, a prosecution against them. If anything, Mr. Sauber...
It seems like his actions in telling witnesses not to talk would suggest that he's hoping they don't talk and that there won't be... He knows there's going to be an investigation. But if none of the witnesses will describe what happened, maybe he won't be charged with a crime. Maybe there won't be an official proceeding. It still seems like he's interfering with an investigation, rather. He's not tampering with evidence that we know is going to be used in an official proceeding at that point. If the witnesses don't say anything, if police don't end up feeling like they have enough evidence, then there's no official proceeding.
Yes, Your Honor, but the defendant's intent shows that maybe he doesn't want one, then that still presupposes that there could be one, and it doesn't require that the state prove that he knew that one was absolutely going to be initiated.
Well, it says about to be filed, so that suggests that he does need to know that it's absolutely going to be initiated, doesn't it?
Yes, Your Honor, it says about to be, and it doesn't specify what the timing is, and here I don't think you could get anything closer than what happened. He was arrested within 8 hours, and they knew that he was the assailant within an hour.
But your rule would encompass the scenario that we've talked about where just as soon as the 911 call comes in, you're suggesting that there's an official proceeding that has commenced. And if someone's not arrested until, what would be your time frame? It's 3 days later when they're arrested, but he told someone to throw away the knife 2 minutes after the crime. He's tampered with evidence. If he's not arrested, if they don't find out about it for 1 week, what would be your rule that you're proposing?
I would say the rule in the language that Division 2 used in Neal, I know it's not binding, but it's persuasive, and it says, the jury may infer the mental state, in this case, whether he knew a proceeding was about to be instituted from his behaviors and other circumstances surrounding the event. And here, I don't think it could be more clear. And another fact that I don't think has really been discussed is after the fact, after he's in jail, although the Mr. Savarino, his cellmate, didn't go and tamper with any evidence, he was still trying to get evidence manipulated around his conviction because he asked him to go plant the knife in the ditch. That didn't happen, of course.
But that wasn't the basis for this charge, was it?
No, Your Honor. But I think that was evidence for the jury to consider, although it wasn't surrounding the event. That was other evidence that was before the jury.
Let me ask you about something you said a few moments ago. You said the police knew who the suspects were. But they may have known the names of the boys who were at the fight, but they didn't know who stabbed Alex for several hours, right?
I believe they knew right away because Xavier and Tim went back to Tim's house and they called the officers right away. And the school, one of the officers, I'm sorry I forgot the name, said, hey, we know who these assailants are. Let's call the school resource officers so we can figure out where these boys are, where their locations are, so we can go and arrest them. So I do believe they did know who the assailant was.
Okay, what does the record show about when specifically they knew that Mr. Larriba Tucker was the one who stabbed Alex?
As soon as the officers were at the scene, I believe they knew that he was the assailant.
But the evidence had already been disposed of by then, correct?
Yes, Your Honor.
So the evidence is disposed of before they identify the suspect. How can there be an imminent criminal prosecution if they don't know who the suspect is at the time the evidence is disposed of?
The imminent prosecution is something I keep going back to is the timing. I mean, very rarely does a crime happen and charges are filed instantaneously within 10 minutes. There is a portion where charges need to be filed, whether officers talk to the prosecution, they need to go and arrest the person. And so in this instance,
They need to investigate,
they do need to investigate.
which was taken out of the statute.
Yes, Your Honor, but a criminal prosecution was kept in, and in Neal, for persuasive reasons, there the court said that the circumstances showed that the defendant knew there was an investigation and a prosecution by his actions when he disposed of the drugs in front of the officer.
We have a long line of cases that suggest when there's kind of a conscious choice to omit a word from a statute, that means something. It was in the model penal code, it was in a previous version, and we've now adopted something that doesn't include that. Why isn't that more significant than a memorandum decision somewhere? When the legislature itself has told us we don't want this word in there. And isn't there a simple fix? If the state thinks it should be investigation, why not ask the legislature to include that word in the statute?
I agree that this word investigation was omitted from the statute, but here there's enough to show that he knew there was an official proceeding. One point I want to respond to my friend on the other side where he cites the Oregon case for the rule he asked this court to adopt. And in the reasoning there where it says the future actions of a third party is an element of offense, evidence of the defendant knows of a circumstance that will cause the requisite actions of a third party to occur can in some circumstances create that inference of knowledge. The case that Oregon relied on was a hot check case, and there the defendant argued that there was insufficient evidence that the bank would not honor his check until it was processed. Well, there the court rejected it because he said he had insufficient funds in his account. He knew of that fact that would cause the bank to reject it. Here, the fact that the defendant knew that a third party would act, he told the detective in his interview that he thought he broke his knife when he stabbed Alex. He knew that he stabbed him, he knew he broke the knife, and I think the other facts to do show his knowledge and can infer surrounding the event that he knew an official proceeding was about to be instituted. Going to count 4, unless this court has any other questions for count 7 and 8. One point I would like to make, but I feel like has not been addressed in the record, is my friend argues that no snitching is susceptible to 2 different meetings, and that the state had the burden to prove what it actually meant. And I think 2 important witnesses have not been discussed and rightly should. The first one is Mr. Savarino, and on redirect, on pages 41, 43, and 44, he testified that his life had been threatened in jail since he was labeled a snitch, and he defined what a snitch was to the jury. The prosecutor specifically asked him point blank, what is snitching? He says, it's here, it's what I'm doing right now. I'm testifying in a criminal trial. He said that
Go ahead.
The term could mean something different in jail than it means to high school students, right?
it could, but the terms no snitching, as this court noted, the connotations with it are usually violent. I mean, everybody knows snitches get stitches. When I was not much older than the people behind me, Lil Wayne came out with a rap song called Snitch. It's in an episode of Parks and Rec. Everybody knows that snitches get stitches. The term snitch means a rat, and there's violence that's associated with the term. And getting to the witnesses here, yes, it wasn't a prison scenario. These boys were out of custody. I think another witness that helps...
Why not ask the boys themselves as opposed to someone who's not the subject of the charge, the statements to the person in prison? Why not ask the boys what they interpreted the term to mean?
The state could have done that. What the state did present, the very first witness that testified at trial was the state's cold expert, Amy Hale. She was a forensic interview at Phoenix Children's Hospital, and she talked about how children, and keep in mind these are a bunch of 15 and 16-year-old kids, respond to threats, and that threats can be subtle to kids, and they aren't overly aggressive, such as, this is our secret. She also discussed how a physical threat can be implied when the suspect is someone that has displayed dominance or power within the child's life, and that can include physical violence. It makes the child feel, if I know what this person is capable of. A couple circumstances that I think are also worth pointing out. In addition to that, this defendant was 6'3", 200 pounds in front of a bunch of high school kids.
He was about 10 years older than his brother?
Correct, Your Honor.
So he's about 10 years older than the two people involved.
Yes, Your Honor. So not only was age a factor, and then when he first gets to the scene, Jesse and Frankie, the two witnesses at issue, they said they knew of him, they grew up across the street. When he first walks up, Frankie hears the knife click, and then Alex reaches his hand out to greet him. Whether or not what he's going to do, if that's ambiguous, any uncertainty was removed when he said, "I'm not that nice," and he stabbed him. So Jesse was in the van, but Frankie saw it, he heard the knife, so he knew what the defendant was capable of. So I think that, and his very specific choice of words of no snitching was enough to amount to intimidation, and the jury could reasonably infer that. The only other point that I would make on that, as Your Honors correctly pointed out, is that even if maybe a couple jurors didn't know what snitching meant, I disagree with that because it's such a universal, common phrase. But even if it was susceptible to two different meanings, that means that there was substantial evidence and it was for the jury to consider.
And it seems to me, and I don't mean to put words in your mouth, but you're saying it's such a common term, and the jurors can use their common sense and knowledge in resolving any disputed evidence.
Yes, Your Honor. And I think they can use their common sense about the words that he chose, the actions that he took, and they can also do that based on his actions about whether he knew an official proceeding was about to be instituted. The one other thing I'll note about the intimidation is that my friend on the other side cited Sanchez in his opening brief, and there it wasn't words spoken. It doesn't have to be a specific magic phrase or magic words. There it was the action of taking a photograph. And although the court overturned the conviction because the witness wasn't intimidated, it said it could include nonverbal threats. There it was. So I think intimidation was for the jury to determine, and there was more than sufficient evidence to show that. Even though there wasn't an action, there was very specific words that were chosen by the defendant. And then in Brown, there was there wasn't even a reference to snitching. All he said was keep the code. Those were his words, and the witness knew that that meant the code of not snitching. And there, the court found that that was sufficient evidence. And here, again, the specific words chosen, I think there was more than sufficient for the jury to find.
In the keep the code case, and correct me if I'm right, I don't remember, was there evidence from the, I'll refer to him as the victim, that he knew what keep the code meant?
Yes, he said that he knew it meant not snitching. And here, both boys heard him say not snitching. The other fact I wanted to point out, and I believe Judge Katani, you mentioned this, is that there was chills that were sent down Jesse's spine. And on cross-examination, whenever he was confronted on, his statements, he said, did he say no snitching? And he said, well, it was something to that effect. It was no snitching. Whatever it was, it sent chills down my spine. So that's circumstantial evidence that the way he said it was also intimidating. There's a difference between, don't tell versus don't tell. And the jury was there to view his testimony and how he reacted to that statement. And I see my time is out. And I would ask this court to affirm the convictions and sentences.
Thank you.
A minor point on the no snitching. I am not prepared to respond to evidence of Little Wayne or Parks and Recreation.
Well, it is common knowledge, isn't that?
Well, this is what I'm saying. I don't think it is. I mean, if it was common knowledge, there was no...
If I asked people in this room what snitching meant, we would get a mix of hands?
I think it's clear what no snitching means. No snitching means don't be an informant. The question is, if somebody says that, does that mean I'm going to hurt you if you become an informant?
Do you think that's a term of endearment?
Well, no, but...
Well, of course not. It's derogatory. It's forceful. Don't snitch.
Right, but does it carry a true threat? That's the issue, and that's the issue. You're going to decide it. But with regard to the official proceeding, the exchange was all about, well, when did they know they were going to charge him? But that's not really the issue. It's not when did the police know they were going to charge Larriba Tucker. It's when he was aware of a circumstance that supports the inference that he knew that an official proceeding was about to commence. And when he was arrested, that would be the first circumstance in evidence of him having that knowledge. And these other cases, the one Oregon, the memorandum decision, those are consistent with what I'm saying. So in the memorandum decision, what the court reasoned was that they put him under arrest for what they had just seen him do. So this isn't like, you can say, well, they're going to continue the investigation and he doesn't know, he doesn't know that an official proceeding is about to be instituted, but if you will, he should have known because he's being arrested. And, it was the same with the Oregon case, which I forget now, but it was a situation where the guy knew the cops had him, and that's when, that would be the earliest in situations like this where, a person can...
So you would say an arrest would equate to knowledge that an official proceeding is about to be commenced?
What I'll carefully say is that would be the earliest, so,
You'd be pretty hard pressed to say that upon arrest, you don't know an official proceeding is about to be.
I suppose I would be hard pressed, but if you give me time, maybe I'll think of something. But I don't need to do that here. So
the court charges are going to be filed if you're arrested. That seems like a pretty good indicator.
Seems like it. I mean, if it's a marijuana charge, you might be still hoping, they're not going to charge me or something because blah blah blah. Well, and now you wouldn't anyway because it's legal, I suppose. But there are situations where the police let people go, but I'm not going to press that. But if you have any other further questions, I mean, I guess I'm kind of out of things to say. Although I have 2 minutes, I'd like to chat with you, but okay. Thank you.
Thank you.
Thank you both for your arguments. They're interesting issues. Thank you for all of you who have attended and for being courteous and observing these proceedings. And with that, we're adjourned and decision will be issued in due course. Thank you.